So, today, good morning, friends. We will be talking on admission deeds, how to counter this pleading for old grant bungalows, or even in lease cases, because somewhere it is. That this is where the concept of admission deed crept in on my old grant, which was a revenue free private estate. It will be an exemplary case study and would be the first case of fraud in the history of Indian judiciary if adjudicated in the true spirit of justice under law of jurisprudence and heard by a constitutional bench. That the executives, which is the Ministry of Defense through its DG lands, on page have very clearly stipulated every executive order, wide this section 34 on page 776, chapter 24, no property to be transferred till transferee admits government titles over grants. An executive order was passed with Government of India, Ministry of Defense letter 730 dated 29/3 1978 that no sale would be allowed without this admission. That on contrary, the executive maintains the land records under CLA rules 1937, which wide section 43 states how MU has to record the transfer with the information also if he does not have information. That this maxima tried to spill the beans is that when the same is applied to the working of the British Army or the Governor General or the Commander in Chief in either of the presidency is called omnia prosumentur writ esse acta, which means all facts are presumed to be done, but whether the same was truly done is a presumption, and presumption is challengeable in law if you can prove it on a contrary. So, what did the British Army or an officer have been doing is that they have been subjecting military regulations to these non resumed old grant revenue free private estates in possession of the native Indians of their original old grant private states holders, which were revenue free. Now, native Indians holding these old grant revenue free private estates in the passage of time and on the making of military camps or stations, which were later called military cantonments, entered into sale of these old grant revenue free private estates with British officers on a fee simple grant, terms which the Britisher officer understood. The same British in 16th century had applied this maxima in England called the omnia. Means all everything is the neutral plural of ominous. All every while omer means love. Vincit is a form of vincere, to conquer or to win, which is also the source of the word of the day victroin. Omnia vincit amor was first recorded in English in the late 16th century. This act meant record proceedings, official acts, transactions, the act of the conference, to narratives of deeds. The British officers, garnered sale deeds registered under the Bengal Registration Act. Later, when the British officer or the commanding in chief realized that these old grant revenue free private estates could be sold only and only by the board of revenue officers, and on after resumption for non-payment of revenue. And as such, these old grants, which were revenue free private estates, were revenue free grants which had been recognized due to long possession of my predecessor. So, native Indians were in possession, and later British officers, now in the order of the Honorable Judge in a Calcutta High Court in 1865, very clearly brewed the minds of the British officers and stated that all old revenue free grants have to be recognized. Now, what the Britishers or the British officer, after the making of the Cantonment Act 1864, and finally the Cantonment Code 1899, then in 1912, subsequently Cantonment Land Administration Rules 1925, 1937, these British officers in chair played with the maxima. Now, this maxima is ante litem mortem, which is a Latin term that translates to before the lawsuit starts or before the controversy began. This legal concept is important in understanding the admissibility of certain statements or declaration in courts, particularly those made before any legal dispute rose. That is why they asked for admission deeds from these old grant revenue free land occupancy holders to acknowledge government rights in the soil and admit being a grant under either GGO made for the three presidencies. With the passage of time and court cases and disputes on these old grant revenue free private estates, bungalows, land records were tampered and misrule was at its rampart, and the illegal act on the maxima post litem mortem, which is once again a Latin term for after a lawsuit is started. Something was before the lawsuit, now when it is started. A litigant or a witness may not create evidence to prove one's case or testimony, which they did by forging the land records and usurping old vernacular records dating from 1833, the house property register, with in any given cantonment or the decimal settlements of 1793 land registers. Friends, please wake up. We were revenue free grants. We were never old grants as termed under a GGO 179. Thank you. Good day.